Good evening to everyone. I thank Mr. GK for arranging this program. So I'm now a new person to this webinar. This is the first time I am handling this webinar. So please pardon me. So during the year 2017, GST has been enacted. So nearly 8 years have been lapsed. Still, the people are struggling much in every aspect, from registration to cancellation, revocation, payment of tax, availing input tax credit, everything is there. So besides, one among the heavy burden is appeal remedies. So as on date, even though there are appeal remedies for Commissioner Appeals, Appellate Tribunal, High Court, Supreme Court, so still the inter between the Appellate Tribunal has not yet been constituted. So now the benches are constituted, but now the members have not filled up in all the tribunals. So the tribunal now, the tribunal is given power to regulate its own procedure, and accordingly, next slide. Accordingly, the tribunal made the procedure 2025 published in GSR 256 year dated 24/4/2025. The rulings came into effect from 24/4/2025. Next. So usually, most of the people dealing in taxation matter, they are well known about the appellate tribunal. So income tax tribunal, income appellate tribunal, so STAT, so NCLT. So there are so many appellate tribunals. So for all this, all the rules may be similar, more or less similar, except the procedural aspect. So the filing appeal before the GST Appellate Tribunal is provided under Section 112 of the CJ Act 2017. So according to the section, any person can file appeal against the order passed under Section 107 of the Act, that is, the order of the first appellate authority. That is, the order passed by the Commissioner CGST, and the order of revision under Section 108 of the Act. So against this order, appeal can be filed before the GST Appellate Tribunal. The next. So the constitution, the bench has already been constituted. There are two types of benches: only principal bench and state benches. Principal bench is located at New Delhi, and state benches are located in 31 benches all over India. So especially each state has one tribunal. So who are the members of the appellate tribunal? So there is a president, a judicial member, a technical member belonging to the central government, a technical member belonging to the state government. So at a bench, there are three members: one president, two technical members. So the age for the, then we can come to the age criteria. The president of the tribunal, the age shall be more than 50 years. So below 50 years, they cannot be appointed as president. The tenure is 4 years. President tenure is 4 years, subject to a maximum of 70 years. So beyond 70 years, nobody can act as president. For technical members, they have also the tenure 4 years, subject to a maximum of 67 years. So maximum president is 70 years, maximum for technical members is 67 years. Both the president and the members are eligible for reappointment once the tenure is over, not exceeding 2 years. So the reappointment 2 years, subject to the maximum age limit. So whatever, so whether first appointment or second appointment, the age limit is 70 years and 67 years respectively. So then next we come to the functioning time of the tribunal. So the tribunal will function from 10:30 a.m. to 1:30 p.m. and in the evening 2:30 p.m. to 4:30 p.m. for administrative officers. So the registrar and the filing method, everything So the function starts from 9:30 a.m. to 6 p.m. So it is usual to all tribunals. Functions of the registrar. So the administrative officer is having a registrar who is fully in charge of the conducting the receiving the appeal, numbering the appeal, preparing cost list, passing orders, everything. The functions is listed with the registrar. The registrar is in charge of receiving appeal papers from the appellants. So once the receive appeal paper, the registrar will check the same, so whether it is incomplete, whether it is complete or not. So if not complete, they will return it for rectifying the mistake. So once it is admitted, the registrar will number the appeal. How whether he can earn his own number, he cannot do it. Numbering can be done only with the approval of the appellate tribunal. So then he monitoring the conduct of the case in entirety from the beginning to the passing of the order. So the sole responsibility is on the registrar, who is having the vital role in the appeal procedures. So we have seen the functioning of the office. Then we are going to see the appeal procedure, how to file. So first we have to, if any litigation, we have to see the limitation period. So what is the limitation period for filing appeal before the GST tribunal? So normally three months is prescribed for everything. So for like that, in these rules also, 3 months is prescribed for limitation for filing appeal from the date of receipt of the order, not the date of the order. So you have to be careful. So it is from the date of receipt of the order. Even today, suppose today the order has been pronounced. So the order may be received next week or 1 month. So whenever you receive the order, then the limitation starts. So 3 months limitation. So how to compute? In computing the time limit, 3 months, it starts from the day which the said period is to be reckoned shall be excluded, and the last day expires on a day when the office of the appellate tribunal is closed. That day and successive days on which the appellate tribunal remains closed shall be excluded. So the 3 months calculation, so the date of receipt of the order is to be excluded. So suppose today you are receiving the order means today is not counted as limitation period. Like that, the ending period. So the end of the 3 months closed, the tribunal is closed for whatever reason, whether it is public holiday or Sunday. So the such holidays at the time of close shall be also excluded. So next, GK. So the form meant for filing appeal is GST APL 05. So it should be clearly kept in mind. So the form for filing appeal, because there are so many forms prescribed in the GST Act and rules. So the correct form is GST APL 05. The appeal shall be divided into paragraphs. So normally it is usual procedure in all cases, and shall be numbered consecutively. So each paragraph should be numbered as 1, 2, 3, and each paragraph shall contain as nearly as may be a separate fact or allegation or point. So it is to be noted clearly. So whatever each paragraph should contain a separate fact or allegation or point. So the appeal paper also contains the full name of the appellant, the percentage of the GST, GST number, description of each party, and address as applicable shall also be set out at the beginning of the appeal. It shall not be repeated. So in the title, so who is the appellant? Who is the opposite parties? So the once it is mentioned, it's not required to repeat again and again in the appeal papers. So it is a criteria first before appeal filed before the GST appellate tribunal. appellate is so and so, opposite parties, the commissioner or so and so. So whatever person, either he may be 1% or 3% or 5%, according to the nature of the facts and circumstances cases. That's it. So every form of appeal shall set forth concisely, not elaborately. So it should be concisely under distinct heads. So why it is told it should be furnished under distinct heads? So then will be easily readable by the judges. So they can otherwise they have to go through everything and they have to form an idea and they have to decide the case. So if it is done as the appeal in paragraphs, which distinct gets, then it will be easy for them to read the appeal papers and come to a conclusions. Next, the grounds of appeal. So it's a very much important. The grounds of appeal and such grounds shall be numbered consecutively and shall be typed in double space of the paper. So the spacing also is important. It should be 1.5 or 2 or 3.5. So it should be double spaced on this paper. That's it. So before the tribunal, so appellate may file appeal, department may file cross applications, or reference applications may be filed, stay applications may be filed to prevent the recovery procedures, etc., and any other miscellaneous. So many applications shall be filed. So whatever the applications shall be filed, it should be typed neatly in double space as already done on A4 size paper. A4 size paper, each page should be clearly paged and indexed. So after completing all these things, so in the front page you have to give an index. So index it will contain whatever the papers from page to page. Every form of appeal or application or cross objection shall be signed. So it is very much important. So many people will sign at the last page and do not sign in the every pages. So in the as per this appeal is concerned, each page should be filed, signed by and verified by the appellant. Verification at the end of the appeal paper, appellant or applicant or respondent or the authorized representative and shall certify as a true copy of the documents produced before the appellate tribunal. So what is the verification? So he will prepare the appeal, he give the grounds of the appeal, you give the list of the documents for the purpose of the appeal. So everything stitched and presented in the index. So those who file the appeal should verify. So certifying that the documents produced before the appellate tribunal are true copy. So next things. So documents. So once the very mere appeal is not enough. So you have to prove it. So with the help of the documents. So along with the appeals, necessary documents to prove the cases to be filed. So these documents should be certified copy of the first certificate copy of the order. So the first and foremost important document is certified copy of the order passed in appellate authority or revisional authority along with the order of the original authority with relevant documents. With the relevant documents, including relayed upon documents. What is the relayed upon documents? So with the help of the documents, the appellant will prove his grounds of appeal. At the foot of every appeal or pleading along with the relevant documents, including relevant documents, there shall appear the name and the signature of the authorized representative, and every appeal or pleading shall be signed and verified by the party concerned and the manner. So it is already I have told. So each and every page should be signed. So additionally, the name of the name of the authorized representative or the appellant or his relative. So whomsoever filed, it should be contained in all pages, and in the final it should be verified by the party. So now we see who should verify. So before that, so we are going to file documents. So in which language it should be there? So there are so many in Tamil Nadu. It should be in Tamil. People may prefer Tamil. In Kannada, they Kannada. So people may prefer on their own language, but a document other than English language. So if a document is in Tamil, it should be it should not be used as a document. It should contain the translated copy of the translated version of the concerned Tamil or regional language. So a document other than English language. So it should be noted a document other than English language intended to be used. Intended to be used. The appellant is wishing to use the document in any proceedings. So that it may be appeal or it may be cross objection or it may be stay application. Whatever there should be accompanied by a translated copy in English, which is agreed to by both the parties. So it is important. So you may translate on your own version, but it may not fulfill the contents of the English Tamil language document. So it should be agreed by both the parties, means appellant and opposite parties, are certified to be a true and translated copy of the authorized representative engaged on behalf of the parties in this case. So all the documents should be in English. So if it is not in English, it is in other regional languages. It should be translated in English, and it should be confirmed as a true copy by both the parties. So next item, what is the fees payable for the appeal before the tribunal? So we see there are appeal, revision, state petition, visualization, petition, and appeal. So usually the tribunal charge 5,000 rupees as fees. The fee structure is the fees for filing of appeal for or restoration appeal shall be rupees 1,000 for every rupees 1 lakh. 1 lakh of tax or input tax credit involved or the difference of tax input tax credit. So whatever the amount, so for every 1 lakh rupees 1,000 fees is required to be paid. But the rules prescribe minimum as well as maximum. So the minimum fee is payable is 5,000. So for the amount involved is 5,000, 5 lakhs, it is 5,000 up to 5,000. So if it's 10 lakhs, 10,000. If it is 1 crore, so the maximum 25,000. So the normal fees is minimum fees is 5,000, maximum fees is 25,000. The fees for filing appeal in respect of an order not involving. So the order, if any order does not contain demand of tax, interest, fine, fee, or penalty. In such cases also the minimum fees is payable. So whatever the appeal we are going to file, the minimum fees is 5,000, maximum fees is 25,000 according to the range of the amount. There shall be no fee for application made before the appellate tribunal for rectification errors. So this is mostly done by the department. So once the department files anything cross objection or a rectification, there will be no fees payable to the tribunal. So because both are same governments. That's right. Verification of. So the appeal papers are ready. So we are preparing appeal. We are preparing the grounds of appeal. So the grounds, each and everything is laid in paragraph, which numbers, and it is duly verified, and each page is signed. So fees is paid. So lastly, it should be verified. So the appellant may be an individual, it may be a company, may be a firm, association, or etc. So if it is an individual, it should be verified by the appellant himself. If it is a Hindu undivided family, the appeal should be filed by the Karta of the Hindu undivided family. Other things, company, firms, association, trust, so etc. The authorized signatory. So the company is not a natural person. So company cannot verify. So on behalf of the company, some person may sign. So for that purpose, they appoint somebody by passing resolutions. So the such persons are called authorized signatory. In case of appeal filed by the company, firms, association, trust, etc., the same shall be verified by the authorized signatory engaged by the companies or firms, etc., and for this purpose. So another important point, so the data presentation of appeal. So the data presentation of appeal will decide the limitation. So if the data presentation of appeal is within the limitation period, then the appeal will be allowed. So what is the data? Normally, when we are filed appeal, it will be the data presentation. So in case manually, the data on which it is presented are deemed to have been presented and shall sign the endorsement if the appeal is filed manually. So manually should be endorsed. Otherwise, now the appeals are only online. So no manual filing unless otherwise there is a problem in the system. So manual filing will not be there. So if so, it will be the data filing the appeal manually will be the data presentation of the appeal. Yes. So once the application is already we have seen, the duty of registrar is to receive the application, to verify the application. If there is any defect in the application, it should be written to the appellant for rectification. So this is discussed here. The registrar may for sufficient cost. The registrar may for sufficient cost. So return the said document for rectification of amendment. So if there is any error or anything, so it will be returned for rectification of the error or amendment of the appeal. So this should be, what is the time limit for it? So it should be complied within 7 days. Within 7 days from the date of return of the application by the registrar for rectifying defect or for some any reason. Any reason it may be extended by registrar, but the extension cannot go beyond 30 days from the date of filing of the appeal. If the defects are not corrected, so the rectifications are not made within the time, then the appeal may be rejected. So there is another point. Delay continuation. So it is a usual procedure. So in every litigation, there will be delay continuation there, but the period may be differ from legal authority. So if the appeal application is filed beyond the limitation period, so after 3 months of the period, the said appeal shall be filed. The appellant shall file a separate application for the delay continuation. In that application, he has to mention all these things when he received the order, when he filed the appeal. So whether it is beyond the limitation period, if it is beyond the limitation period, so what is the reason for the delay? So he has to satisfy the registrar. So sufficient cause. So if the registrar is satisfied, then it will be condoned. So if the appeal bar application is filed beyond the limitation period, the said appeal bar application cross objections and application shall be filed before the appellate tribunal for the condonation of delay. So the applicant is to state the reasons that prevented him from filing the appeal for application for cross objection within the time. So sorry, I told the delay continuation with the registrar. So the power of delay continuation only the tribunal, not the registrar. If there is a delay, the registrar will put before the tribunal whether it may be condoned or not. The appellate tribunal may admit an appeal within 3 months after the expiry of the limitation period, or permit the filing of application by department within 3 months after the expiry of the limitation period, or the memorandum of cross objection within 45 days after the expiry of the limitation period, if it is satisfied that there was sufficient cause for not proceeding within that period. So limitation period is prescribed to 3 months for the normal taxpayers. So for the department, it is for 3 years. if any cross objection is to be filed, it should be filed within 45 days. So if there is a delay, so for each delay, they have to file a separate application for continuing the delay, indicating the details for the reasons preventing them from filing the appeal. If the reasons given by them is satisfied by the tribunal, then it will be allowed, or the application will, the appeal will be rejected. Okay, sir. Scrutiny of the application. The appellate tribunal may, on its own most, direct preparation of as many as copies of record of all the relevant documents, including reliant upon documents, and at the cost of the appellant or the respondent, containing copies of such statements, papers. So we are preparing the appeal. So it will be supplied to the opposite parties. The opposite parties may be one person or more. So definitely it should be given to commission department. So 2 copies should be given to the tribunal. So because sorry, if there are 3 members, 3 copies. So unless whatever the parties made, say that it is 10 or 5, so the appeal papers should be prepared accordingly. So according to the number of parties involved in the appeal. Acknowledgement. The acknowledgement means it is the acknowledgement for receipt of the appeal. So when how is if the order is uploaded in the portal, what is the order? So the order against which the appeal is going to be filed, not the order of the tribunals. The order which against which the appeal is filed, it should be uploaded in the portal. A final acknowledgement will containing the appeal number will be given. So acknowledgement will be given in the form GST APL number 2. So when would be given apply? So if the appeal is completely in conformity the rules, then it will be given. If there is any error, it will be rectified. After rectification only, it will be acknowledged. So if the rectification is not done, it will be summarily rejected. Where the order appealed against is not uploaded on the common portal, the applicant shall submit or upload a self-certified copy of the said order within a period of 7 days from the date of filing of Form GST Appeal 05. So normally the order of the order will be uploaded in the portal. If it is not uploaded, the appellant may furnish a self-certified copy of the order within a period of 7 days. 7 days from the date of filing of appeal before the registrar. So it is important. So these are the small things which may be without notify will be left. The final acknowledgement indicating the appeal number shall be issued in form GST Appeal 2 already be seen on removal of defects, and the date of issue of the provisional acknowledgement shall be considered as the date of filing of the appeal. So what once we file appeal, a provisional acknowledgement will be given to the appellant. Okay. So once whomsoever filing the appeal, the provisional acknowledgement will be given. When the appeal paper is complete means the appeal is in compliance with the rules and provisions of the Act and rules, or it has been rectified. So everything it is perfect. Then the final acknowledgement will be given in April GST Appeal number 2. Next. So it admission as appeal. So it is a previous before acknowledgement. So once that appeal is administered, then will be the acknowledgement will be given. On admission of the appeal, the same shall be numbered and registered in the appropriate register maintained in this behalf, and its number shall be entered therein. It is the duty of the registrar. So the registrar receives the application of appeal papers from you, from the appellant. You verify it. He found it defects. He gave it to the appellant for rectification. The appellant rectified it and returned it. So then he everything is found. And approval of the tribunal, it is admitted. So for this purpose, a separate register is maintained in the office of the tribunal. So it is the duty of the registrar to enter all the details of the appeal from the appeal number, and everything is entered in the register. So he is the person to monitoring this appeal. So this is the duty for Western running. The arithmetical, grammatical, clerical, and such other errors may be rectified on the orders of the registrar without notice to the parties. So rectification. So rectification may be many kind. So it may be simple or clerical error or a total mistake or grammar mistake. So for such things, the registrar is not required to obtain the approval of the tribunal. So he himself may order. So once the appeal paper is received, the registrar scrutinizing all these things, then he put up before the members of the appellate tribunal. So if there is any defect, then the tribunal will direct for rectification of the mistakes. So if the mistake is such that arithmetical mistake, grammatical mistake, clerical mistake, so and simple mistakes which can be rectified, such orders will be passed by the registrar. So it's not required to go to the appellate tribunal. No such amendments shall be allowed ex-parte after appearance of the respondents. So it is important. So once the respondents in the make appearance of the before the appellate tribunal. So what it says, the appeal will be numbered only after fulfilling all the conditions, including rectification of mistake. So once the appeal is allowed and the hearing is the proceedings is started, no such rectification will be allowed once opposition parties. So previously, whatever we discussed is only on the part of the appellate or whoever. So the other party is not given notice. If there is a mistake in the appeal paper, so the registrar or tribunal will direct to rectify it. So this copy will not be furnished to opposite party and challenge it. So, pre-deposit. So another very important aspect in filing appeal is pre-deposit. So in this regard, there are so many case laws, including the first appellate authority, including tribunal is just came here, but in respect of income tax says that. So the pre-deposit faces many hurdles. So because the appellate maybe not enough having money. So there are so many case laws, litigations are pre-disciplined. So the taxpayers practices is to consider the pre-deposit as a main important point in filing the appeal. So first is some demand interest tax penalty will be imposed on the taxpayer. So whatever, so against this he is going to file appeal. So for 1 crore, so demand of interest 1 crore, but the appellant accept, I agree to pay 30 lakhs. So that such amount shall be filed as a pre-deposit. So the remaining amount will be kept in dispute. So such amount, a sum equal to the 10% of the remaining dispute. So for 1 crore disputed tax. So the appellant consider he has to pay, he will be pay rupees 30 lakhs as pre-deposit. So which other remaining 70 lakhs will be in dispute. So what is the rule say? The appellant should pay the accepted amount, say 30 lakhs. So again, beside this, a sum equal to 10% of the remaining amount. So 70 lakhs is the remaining amount. So 70 lakhs is 10%, 7 lakhs. So he has to pay 30 plus 7, 37 lakhs as pre-deposit. So the rule prescribed maximum pre-deposit. It is rupees 20 crores. 20 crore up to 20 crores. More after 20 crores pre-deposit is paid. So after 20, whatever the amount, it is restricted to 20 crores. In case of any order demanding penalty without involving demand of any tax, no appeal shall be filed against such orders unless sum equal to 10% of said penalty, in addition to the penalty payable under the provision to section scheme paid by the appellant. So, if the appeal is only for penalty, he has to pay 10% of the penalty amount. So, on payment of the said amount, the recovery proceedings for the balance amount shall be deemed to be stayed for till the disposal appeal. So once the appellant paid the requisite amount of pre-deposit, then for the remaining amount, there's an automatic stay. It is not required to file a separate application for the stay of the balance amount for recovery tax. So once he paid the entire pre-deposit, automatic stay is there. Stay will come for the given to the department. The balance amount shall not be recovered till the disposal of the appeal. So it is the privilege to the appellant. Okay, sir. Next, sir. So this has already been discussed. A copy of each appeal and relevant documents along with the related upon documents shall be provided to the respondent as well as to the concerned commissioner as the case may be, as soon as they are filed for filing reply or cross examination. So even if the department is given reply to the appeal, then they have to give the documents on which they are relying to the appellant and the tribunal 3 copies. That's all. So it is already there. So once the application filed, replies to filed, any person want to file cross objection. The cross objection, it should be filed within 45 days of the receipt of the notice. The maximum cross objection will be filed only by the department. So the department has to file cross objection within 45 days from the receipt of the appeal papers from the appellant. So the for the memorandum of cross examination, there is a form is prescribed. It is GST APL 06. So this cross objections as well as reply are verified in the prescribed manner. So whatever the procedure described for the appeal is also applicable to the reply, cross objection, etc. Everything. Next, filing of reply. Each respondent may file his reply to the petition or the application and copies of the documents either in person or through an authorized representative with the registrar as specified in the appellate tribunal within 1 month of the receipt thereof. So once the appeal is filed, a copy of the appeal will be sent to the department as a concerned person. If any third party is involved, then such persons are liable to file reply to the tribunal within 1 month of the receipt of the appeal papers from the tribunal. A copy of such reply and the copies of the other documents shall be forthwith served on the applicant by the respondent. So whomsoever you file பண்ண, the said person will send all these things to the other persons. Rejoinder. So rejoinder is form of some privilege given to the any person, either the appellant or so the appellant file appeal, reply will be given. So if the appellant filed, so any specific ground which is left, then he may file rejoinder. If the respondent says such additional facts as may be necessary for the decision of the case, then he may file rejoinder before the tribunal. So the same procedure for appealing, filing appeal will be also applicable to the rejoinder. A copy of such reply and the copies of the other documents shall be forthwith served on the applicant by the respondent. Next one. So we have still till time discuss the procedure for filing in appeal. So then what is the procedure to be adopted by the tribunal? So for civil cases, civil procedure code is there. So they have to follow the procedure provisions of the civil procedure code. In criminal cases, the criminal courts have to follow the procedure of criminal procedure code, not Indian penal code. Indian penal code is only for giving details of punishment. So whether the tribunal is only dealing with the civil cases, it is not a criminal cases. So even though there is a prosecution there, so normally these GST tax matters are civil cases. So for that purpose only, they are not required. The tribunals are not required to follow the principles of civil procedure code, but they have to guide it by the principles of natural justice. So what is the natural justice? Each party should be heard. So now nobody should left without hearing the and giving opportunity to everyone. So it is applicable to all. It is applicable to the appellant. It is applicable to the department. It is applicable to the party whom they are involved in this appeal. So this is the main principles. So the adopting the principles of natural justice. So besides that, so for that purpose, the rules provided that the appellate tribunal shall have power to regulate its own procedure. So the tribunal may complying with the principles of natural justice, they have to frame their own procedure. Excellent. Some civil court powers are given to the GST appellate tribunals. So it's normally given, powers normally given to the quasi-judicial authorities like tribunals or anything. So whatever to summon and enforcing the attendance of any person and examining in on both. So if we required for the deciding appeal, if it is required to call for any person to give evidence or produce documents, then it may summon the concerned person. Requiring the discovery of the production of documents. Receiving evidence on affidavits, subject to the provisions of the section 123, 124 in Indian Evidence Act. So the Indian Evidence Act is abolished. So Bharatiya Sakshya Adhiniyam. So this 70 and 80 of the success. The requisition any public or document, a copy of such record or document from any official. Issuing commissions for the examination of witness or documents. Dismissing representation for default of deciding it ex-parte. Setting aside any order dismissal of any representation for default any number passed by ex-parte and any other matters. So in some cases, in some tribunals, the tribunals are will be given to dismiss the case ex-parte, but powers will not be given to set aside the ex-parte. So, but in this case, clearly it is given. So once the tribunal pass any order ex-parte, so then concerned agreed person may file an application to set aside the ex-parte order and restore the appeal. That's all. Cost list. So this is a regular procedure of the registrar. So each and every case, whether it is a civil court or high court or supreme court or tribunal, so the registrar is issuing cost list, which gives the details of the case, on which date it is to be conducted, on which court it will come, who are the parties, etc. In the cost list. So for all the judicial bodies are giving cost list daily on their own website. So in the website there is, so if for the hearings today night, the cost list will be uploaded in the GS portal concerned. Like that, so in the GST portal or appellate tribunal portal, the cost list will be published by the registrar. The registrar shall prepare and publish the cost list for the next working day. In GSTAT CDR 01. So for this purpose also, the form is prescribed. GSTAT CDR 1 on the notice board of the appellate tribunal and the GST portal before the closing of working days of the hours on each working day. So for the tomorrow, so there are cases to be heard tomorrow. The cost list of all the cases will be published in the notice board of the tribunal and also the portal at 6 p.m. So 6 p.m. is the closing working period of the administrative office. The listing cases in the daily cost list shall be in the following order. So whatever the items will be in the cost list. Cases for pronouncement of orders. So on the date, order on which cases orders are to be passed. Cases for clarification. So cases for admission. Cases for orders for direction. Part heard cases. Latest past hearing having precedence and the cases posted as a numerical order and as directed by the benches. The adjournment or post direction shall be notified on the notice board on the GST portal. So the cost list is be watched each and every day to the professionals who are dealing with the appeal, who are their clients before the appellate tribunal. So otherwise you will miss the bus. So even sometimes mail, you may receive a mail from the registrar. So next another point, services of notice. So you may come across so many case laws. You may come across case laws. So no notice is served to me. No reasonable opportunity is given to me. No personal hearing is given to me. So such type of cases are the mainly services of notices. I am not receiving the notice from the appellate tribunal. So it is against the principles of natural justice. Any notice or communication may be served by any of the following method as contained in the section 169 of the Act. So 169 clearly provides what is the procedure for sending notices. So in the earlier period, what they do, they will post in the post office and in a normal post, so it may be delivered or may not be delivered. So what is the crucial there is to be followed? The notice should be served on the person concerned. It is a highly required main point for the any judicial proceedings, whether it is appeal or anything. So service of notice on the concerned parties is a must. So the section 169 gives the procedure how the notice to be served. The notice may be given directly to a person concerned, or it may be given by the messenger, including a courier, to the assessee or the taxable person, or to his manager or authorized representative or an advocate. So it is not required it should be served on taxpayer himself. So he is authorized person, he is having office, he is having manager. So the appellant is not required to present all the time in the offices. The office may be the person who is responsible for receiving the doc and dispatching the doc will be may receive it. So the representative, advocate, or chartered accountant, or company secretary, or cost accountant, or a GST practitioner. So who are eligible to appear before the appellate tribunal may receive the notice. So in case of family, the notice served. So the appellant is not available at the time of service of the notice. It should maybe served on the family members of the appellant. So another thing is address. So normally the address is mentioned in the appeal, everything. So the notice will be served on the address given by the appellant. So it may be the correct address or last known address. By sending a communication to his email address provided at the time of registration or as amendment from time to time, making available to the court. So the notice is also served through Gmail. So provided at the time of registration, the appellant provided his Gmail ID to the department, then it may be sent to the Gmail ID. So everyone should be cautious to check the Gmail day to day. Or publication in a newspaper. If it's not able to serve properly, say that to his address, either to his Gmail ID, then newspaper advertisement given. So in the locality where the tribunal, the appellants, other parties are residing, so it should be given in the newspapers only in English, one and regional language. So which is circulated mostly. So if all such is, then the notice may be affixed to the on the premises of the concerned party. Okay. Next slide. So GST proceed. So portal. So we have so far come across the procedure to be adopted by the appellant, the authorized representative like the chartered accountant, company secretary, advocate, etc. The procedure to be followed by the registrar in entertaining applicant, appeal, checking the scrutiny appeal, numbering the appeal, and the role of the tribunal. So how it should be conducted by complying with the principles of natural justice, etc. So all the proceedings before the GST Appellate Tribunal shall be conducted through GST portal, and all such proceedings shall be recorded on the said portal. So it is the latest. So every tribunal, whether it is NCLT or income tribunal, everything is recorded in every proceedings are recorded. So income tax is having a faceless appeal. So for the GST also, GST tribunal also, definitely faceless appeal will come soon. That's it. Mode of hearing. So normally, usually all the in civil or criminal cases, most of the in person, in physical. So since technical development, it is possible even after the corona. So the online appearance before the electronic mode is allowed. So now in every aspect of litigations, physical mode as well as electronic mode is allowed. So the tribunal in the itself, the cost list itself, it will be mentioned. If it is required for personal hearing, it is specifically mentioned in the cost list that the parties should be applied, so should appear before the tribunal physically. Next, sir. Authorized representative. So the appeal shall be appellant shall appear before in all proceedings of the appeal by himself. If it is an individual. For others, it is highly required to appoint authorized representative. If it is a department, so the regular employee of the department or the authorized officer may attend. So here the list is given whom may appear before the tribunal as authorized representative. The relative or regular employee of the tax person or advocate who is entitled to practice in any court of India and who has not been debarred from practicing before any court of law. So, whomsoever he may appoint as authorized representative, he should not be disqualified in his profession. Any chartered accountant, a cost accountant, or a company secretary who holds a certificate of practice and who has not been debarred from the practice by the concerned insured. A retired officer of the commercial tax department of any state government or any territorial or the board who during the service under the government had worked in a post or not below the rank than that of group B gazette officer for a period of less than 2 years. So in respect of department, it's not only if the any department person retired, so automatically they will come to the field for practicing the tax matters. So in the retired commercial tax officer may practice before the tribunal, but condition is he should work as a group B officer. In his employment, he must be the group B officer, and in the group B officer, he has to serve not less than 2 years. So such persons are entitled to appear before the proceedings under the Act for such officer cannot appear 1 year, up to 1 year. After 1 year, they can appear. Any person who has been authorized to act as a GST practitioner or be the concerned registered person. So GST practitioner, there is separate rulings for that. They have to appear the examination. So after passing the examination, they can become GST practitioner. So normally a science degree holders may not be allowed to act as GST practitioners. So only commerce students etc. Like that of engineering students are also not allowed to practice as GST practitioners. But if an engineer graduate is a chartered accountant, then he can practice. He can. Basically, they have they have to gain the knowledge of commercial. So next, empanelment of authorized representatives. So this is the tribunal itself call for empanelment of authorized representatives or valuers. So valuers are other such experts. So the tribunal not only requires for expert authorized representatives, but mainly requires valuers. So to value anything. So suppose in case of import export, valuation problem is there. So many cases are there. So such values may be obtained. Even in the GST valuation is highly required. Or such other experts are acknowledged required by the appellate tribunal to assist. So these experts will assist the tribunal for the proceedings. So for that purpose, the tribunal will call for list experts from the experts or from the public for keeping them in their empanelment. So the remuneration is specified by the appellate tribunal. So next one. Dress code. So it is for representative. So the authorized representatives all wear the same professional code as prescribed in the code of conduct. So for chartered accountants, there is a dress code. For company secretary, there is a dress code. For cost accountant, there is a dress code. For advocate, there is a dress code. So the dress code. Selection. Listing of urgent cases. So it is also an important point to be considered. So in some circumstances, the normal procedure will get delayed. So for urgent purposes, for otherwise the taxpayer will be suffered, then he may request for urgent cases, listing of urgent cases. For that purpose, normally the tribunal up to 12 o'clock, the papers will be received by the registrar. So after 12 o'clock, no paper will be received. They will be directed to come the next day. But in case of urgent cases, up to 12 to 3, they can file application for hearing the cases in an urgent matter in the following day. For the purpose, the appellate tribunal has to give permission for the specific permission for the urgent case, urgent listing cases. So it may be the appellate tribunal or the president. The next. Absence of appellant. So sometimes after filing the cases, the appellant or concerned person may not appear before the tribunal for so many reasons. So it may be for not knowing the hearing date or directions may not receive from the authorized representative. So whatever reasons, if the appellant does not appear when the appeal is called on the hearings, the appellate tribunal may either dismiss the appeal for default or heard and decided on own merit. So if the appellant is absent, then it will be pass ex-parte orders. So if the ex-parte orders are passed, then he have to file an application, so indicating the reasons for his absence. So if the court, the tribunal is satisfied, then the ex-parte order will be restored. So it is the ex-parte order. When on the day fixed for the hearing the appeal or any other day to which the hearing is adjourned, the appellant appears and the respondent does not appear. When the appeal is called for on hearing, the appellant tribunal may hear and decide the appeal as ex parte. So what is this? So the appellant is absent, it is automatic ex parte. So no other person will be. So if the department is not appearing, then the appeal is considered on the basis of the documents produced by the appellant. So the order will pass in the absence of the department. So it is here this is appeal expert means like that. So the order has been passed. Yes. Production of additional evidence. So we see that the appeal papers should be filed along with appeal with the required document evidence. With the required document evidence. Once the appeal is filed, normally additional document evidence will not be allowed. So it is applicable to all litigation proceedings. So for introducing new evidence, the appellant or any person may file an application before the tribunal indicating the reasons for admitting the additional evidence. So the tribunal is satisfied that it may be allowed the additional evidence. So it will allow only after hearing the other party. Next one. Evidence file affidavit. So it is normally adopted in the quasi-judicial bodies. So in the civil and criminal, every witness will be witness in the witness box, and he will be examined, he will be cross-examined, he will re-examine, etc. But in quasi-judicial proceedings, so it may give evidence. So the maximum the evidence only through affidavit. So affidavit means in the written format. So without so each and every fact will be reduced in writing, and for that the document is reduced. So the appellate tribunal may direct the parties to give evidence, if any, by affidavit. Cross-examination. So it is normal in civil and criminal cases. So in quasi-judicial like that of the tribunal cases, normally cross-examination is not allowed. But if it is necessary in the tribunal, in the interest of justice, if it is considered by the tribunal, the cross-examination is necessary for the rendering justice, then the cross-examination of any deponent of the points of conflict may be cross-examined. So cross-examination may be either physical mode or electronic mode or video conferencing. So it is on the decision of the tribunal. So normally cross-examination is not given. So there are some cases. So the appellants filed writ petitions. So for directing the tribunal, so the authorities to allow them cross-examination the deponents. So next, adjournment. So for every hearing, the concerned persons are required to attend before the tribunal. So sometime it may beyond the reasons cannot be able to attend, or for this reasons the authorized representative may ask for adjournment. So if the adjournment appellate tribunal may, if sufficient cause is shown at any stage of hearing, an appeal grant time to the parties or any of them and adjourn the hearing of the appeal for the reasons to be recorded in writing. So such adjournments will be given only 3 times. So it will not be allowed for 4th time. Okay. Next one. Order of the appellate tribunal. So the entire procedure is over. So the tribunal is given new order. So the appellate tribunal may, after giving the parties to the appeal as an opportunity being heard, pass such order. There are as it thinks which. So the order it may whatever it may confirm the appeal, or it may modify the appeal, or it may annul the appeal, or it may remand the matter to the first appellate authority or the reviewing authority or the original authority with directions. The first times. So the order is passed after hearing the parties concerned. So in the order, the appellate tribunal may confirm the order of the first appellate authority, or it may be modify the order of the first authority, or it may set aside or annul the decision of the first authority. So it may be remanded to the first appellate authority or original adjudicating authority to decide the case first after giving reasonable opportunity for parties to consider. Time limit. So the appellate tribunals are, as far as possible, hear and decide every appeal within a period of 1 year from the date on which it is filed. So it is normally it is not happening. So even 5 years, 6 years. So for that purpose, the appellant and the department has to cooperate with the tribunal. Then only it can complete the hearing within 1 year period. Every order of the appellate tribunal shall be in writing in English, and shall be signed and dated by the members constituting the bench concerned. The appellate authority shall, along with this order, issue a summary of the order. So இது வந்து important. Summary of the order in form GST APL 4 clearly indicating the final order demand confirmed. Pronouncement of the order. So now the order till time we have seen the order to be passed. Who will pronounce the order? Any member of the bench may pronounce the order and on behalf of the other members. The members of the bench who heard the case are not readily available or have ceased to be members of the appellate tribunal. The president may authorize any other member to pronounce the order on his behalf. So normally the order is pronounced in the tribunal during the working hours by any member. So if the members not available, subject to the president may authorize or any member to pronounce the order on behalf of the tribunal, subject to the being satisfied that the order has been duly prepared and signed by all the members who had the case. So normally the order should be signed by the members who continuously heard the case. So if such members are present, one among them pronounce order. So if all three members are absent, then the president may authorize any member to pronounce the order. Okay. Forwarding the order copy. So order is ready. So definitely it should be passed to the served to the parties concerned. So the first appellate authority. The order of the appellate tribunal shall be served to the appellate authority or the revisional authority or original adjudicating authority, the appellant, the jurisdictional commissioner of state or central or union territory, etc., etc. So another thing is we may seen many journals, syntax, so taxman, etc., publishing the orders. So only if the tribunal give permission, they will publish such orders. So at the time of passing the order, the orders may be published in the journal subject to such terms and conditions as the appellate tribunal may lay down. So any order cannot be published by any journal independently. Reference to larger bench. In case of different opinion of members bench while hearing appeal, the appeal shall be referred to larger bench by the president and leave it for the disposal of the appeal. So if two members are there, there may be different opinion, 50-50. There is no, but in case of 3 members, so any 2 members pass order, it is majority. Even some cases in complicated cases, the tribunal may refer the matter to the larger bench. They have to apply to president of the appellate tribunal. So the tribunal will, the president will order for the constitution of 5-member bench. Binding nature of the order. So orders passed by the appellate tribunal on an appeal shall be final and binding on the parties unless appeal has been filed against the said order before the High Court order. So today the tribunal passed order. So there is a time limit for filing appeal against the order of the appellate tribunal before the High Court. So until the limitation expires, there is no problem. If the limitation for filing appeal expires, the order is final and it will be binding on the parties concerned. Unless otherwise, there is stay order is obtained from the High Court. Enforcement of order. So once received the order, most of the people will comply with the order. Some people may not comply with the order. even they will not file appeals for the appellate authority. Any order made by the appellate tribunal may be enforced by it in the same manner as with the decree. So it is not a tribunal is not a civil court. It is a quasi judicial. The order passed by the civil and criminal court will be there will be a degree. So against the order will be executed with the help of the degree. But here only order is passed. But the position of the order is equal to the degree of a civil court. So it is considered as a civil court. So the order is executed as per the procedure of the degree by the civil court. So for the purposes of all the procedures contained in the appellate tribunal called judicial proceedings. So even the quasi judicial proceedings for the purpose of sections 193 of Civil Procedure Code and in the IPC, so they are deemed to be civil court for the purpose. Next, appeal to High Court. So the order has been filed. So order has been given. Definitely, any person, one person will be agreed, either the appellate or the department. So any person who is agreed by the order of the appellate tribunal may file an appeal before the High Court within 180 days on which the order is received. So here also, the data received of the order from the appellate tribunal is the criteria for counting the limitation. So it is 180 days, not 6 months. There is a difference from 180 days and 6 months. So if it is 6 months, so we automatically, so today, 1st September, 6 months, September, October, November, December, January, February 28th, 28th is the last date. So, but 180 days now you have to actually count out the days. So in High Court also, if it is a file delayed, so delay contestation petition may be filed. So interest on refund. So the appeal is filed. So the outcome may be confirmed the demand or set aside the demand, anything. So the order is set aside. So the appellant definitely paid pre-deposit. So if we won the case, he is eligible to get the refund of the pre-deposit. Powers of the president. So the president may assign or delegate to the vice president of the state bench some of the functions. So the president president is having power to assign a detail or transfer the appeal from one person to another person, another bench. Yes, sir. Withdrawal of appeal. So once appeal has been filed, so there is a question whether the appeal filed by the appellant may be withdrawn. So the rules provide for the withdrawing of the appeal filed before the appellate tribunal. So the withdrawal form should be the form for withdrawal form GST APL 05 bar W. W indicate withdrawal. So withdrawal should be done within 15 days of from the date of filing of the application. So the appellant withdrawal withdrew the appeal. Now he wants again to file appeal. So whether it is allowed, so the answer is here. If any fresh appeal application is decided to be filed by the appellant, pursuant such a time, the same shall be filed within the time limit of 3 months by the appellant or 6 months by the department as specified in the under section 112. So there is no concession. So you may file appeal. you may withdraw it, but again file it. But the limitation period is 3 months. So if the limitation period expires, so you cannot file any something. Enforcement of order. We already seen the order is treated as a degree of the civil court, and the tribunal. So in case of civil cases, the execution court is different. The one civil court may pass order, and it can be executed only at the execution court. But the order of the appellate tribunal can executed by the tribunal itself, or it may render the help of the local court for enforcement of the order and executive court. Okay, sir. Same. Order sheet. So during the proceedings, so the registrar will maintain a separate case bundle. So if appeal is failed, so we see that the entire details are recorded in the register. So then for each hearing, so from the data admission to passing the final order, there will be a register maintaining a order sheet. So for each day, an order sheet will be maintained by the registrar. The form is for that purposes. GSTAT Form 2. It will contain all orders passed to the interim order or any order passed by the tribunal will be recorded. Okay, sir. Examination of witness. So it should be considered to the, but we deal it separately. The provisions of the orders of 16 and 26 of the Code of Civil Procedure shall apply in the matter of summoning and enforcing of attendance of any person, the examining in oath, and issuing a commissioner for exam. So normally in cases of quasi-judicial, there is no examining the evidence of the persons and cross-examination person. All are only in the form of affidavit. So if it is required to examine interests, then the procedure of CPC should be compulsorily followed. In case of a witness, the deposition of witness shall be recorded in the form GSTAT Form 7. So all his versions will be recorded in paper, and each paper he will sign, and all the members will be signed. Next. So for that purpose, so for exam witness, so it may require the tribunal to summon the concerned person, directing to appear in person before the tribunal. For that purpose, the person who called for evidence should deposit the registrar and the allowances estimated by the registrar before the summon is issued. So if a person is asked to come, he has definitely given the conveyance allowance and the personal expenditure to during the hearing. Such expenditure will be decided by the registrar, and this amount will be paid by the party concerned. Then only the summon will be issued to the concerned person who is required to give witness. Okay, sir. Next. So finally, what are the forms that are to be utilized in the appeal procedure? GSTAT Form number 1, interlocutory application to the appellate tribunal. If any stay order is required to be get, so this form is to be used. GST Form 02 order sheet. So just we have seen, so the order sheet is maintained for each hearing and recorded by this one. GST number 3, inspection. Whoever wants to inspect the records of the appeal papers, he has to apply to the registrar and pay the record fee and get inspected. Number 4, memorandum of appearance. The representative authorized representative shall file this form for getting the permission of the tribunal to appear before the tribunal. GST 5. affidavit by visibly impaired witness. So if a person attended the coming for the giving witness is an impaired witness, then his person will be recorded as affidavit in 05. GST form number 6 summons. In this form, summons will be issued to the person concerned. 7. Deposition of witness. So whatever the person is given by the witness will be recorded in form GSTAT form number 7. Certificate discharge. So once witness given is a person, he will be discharged from the case. So this certificate is granted in GST form number 08. Next one. GST CDR 1 cost list, CDR 2 court diary, CDR 3 register of professional appeals, 04 register of appeals, 05 register of intellectual IA petitions, 06 register of inspection, 07 in Supreme Court cases, 08 High Court. These are maintained by the registrar of the tribunal. Next. Thank you. Thank you to all. So I think I bored you all.
Yes, sir.
Yeah,
This is Sriram from Chennai. A small doubt. So whether the
Hello.
Chennai tribunal, whether it is operational or if not, when it is likely to be operational.
So it will come operation once the members will be posted.
Okay.
They are in the process of recruiting the members.
Okay.
I think I already over. Technical members, they are in the process of selecting the technical members.
Okay. Till such time anything is there, we have to go to IT
Oh,
court.
no. Till such time the previous procedure will follow.
No, sir, because there are cases where the appeal filing with the appellate authority, that is, the AA was missed out. Okay, so in those cases, normally we can go to tribunal till tribunal is formed. We have to go to High Court, right?
So till the tribunal is fully constituted, so the whole procedure is to be adopted in the emergency cases. The taxpayer is approached the High Court only.
Okay, and this pre-deposit is in addition to the money what we paid in initial first appellate authority.
Yeah, pre-deposit, sir. So pre-deposit is a main condition for filing appeals. So without payment of the pre-deposit, no appeal will be entertained. So the rate of pre-deposit is, so for example, 1 crore is demand confirmed towards the tax payable. So you are going to file appeal. Okay. So you may accept full amount or part amount, or even in total you may not accept it. Okay. So if you not accept entirely, you have to pay the 10% of the tax. So tax means it is disputed about.
No, sir, already you would have filed that in the first appeal 10%.
So in the before appellate, so it is different.
So you again have to pay 10%.
So it is I think it will be clarified. So before first appellate authority will be filed. Okay. So
the same acknowledgement I can proof of pre-deposit I can attach in tribunal also. No?
There is no clear instruction. So after the opening of the tribunal, it may come. So your doubt is genuine. So I have to doubly penalized. Okay. So before the first appellate authority, I have to pay. For the second appellate authority, I have to pay. So it will then be there. So what is the procedure in income tax? I don't know.
Sir, in income tax, basically it is on the total amount. If I already filed with first CIT appeals, then the same thing will, because there is in income tax for CIT appeals is 20%. For tribunal level, the percentage is not specifically mentioned.
This is
so we have to go for stay of the entire amount. We have to apply for stay of the entire amount.
So I think after the
because in your presentation, you mentioned over and above 107, whatever we paid under 107. That's what I asked.
So your doubt is genuine. So before the first of all, that I paying the pre-deposit for tribunal, I have to pay pre-deposit. So I will check it up. So what is the procedure available with the GSTAT and the income tax? So and I will revert to you.
Okay, sir. Thank you.
So whether the same principle will applicable or not.
Okay, sir.
So this also I come across such problems in GSTAT.
Okay.
GSTAT even in our case. Now I worked in BSNL and dealt with the service sector.
Okay, sir.
So I will get it and clarified and give it to administrator. So he will
Sure, sir.
Okay.
Thank you
Thank you,
for
sir.
your presentation. Thank you. Thank you.
Okay. Thank you, all the participants. Any query you can ask on the topic, or you can share your views also. Arvindan sir, anything you want to tell?
So you may please give my name and mobile number, email ID.
Yes, yes.
Hmm?
Yes, I will share with all the participants your mobile number and email ID so that they can send the queries, doubts, etc.
So
One minute, sir. Sir,
tell me, sir.
am I audible?
Yes,
Ramakrishnan,
sir.
sir.
Yes, sir. Yes, sir.
Sir, you say that additional evidence cannot be given after filing the appeal, that clause you are referring to. Additional evidence cannot be given after filing the memorandum of appeal. That's what you have told.
Yes,
You
sir.
know,
Yes, sir.
is it not possible while filing that cross objection?
Cross exam in this case, cross objections are filed only by department. So
Department alone.
additional evidence is not in any case. It's not allowed in any appeal in any litigation. So if it is highly required, so in the interest of justice, if it is required and the judicial authority is satisfied, after that only additional evidence, either document evidence or oral evidence will be allowed. Otherwise, it will not be allowed. So for that
It
purpose,
should be done at the time of filing of memorandum.
filing of memorandum,
Beyond the time of memorandum, you cannot add any additional evidence.
memorandum is cross-examination filed by the department.
Yeah.
Okay.
Ah.
They might file all the documents for the support.
Yeah.
So the additional evidence is beyond that. So whatever the documents filed by the appellant and the department. So in due to circumstances cases or during the course of the case, it is required. So the additional document is compulsory, heavily needed for the decision of the order. So
See,
either it may be
in
appellant
cases,
maybe appellant or department.
in those cases where the intelligence wing is conducting inspection, the adjudication proceedings are not happening in accordance with the law. Adjudication is abruptly done. Either the aggrieved party is not appearing before the adjudication, or the adjudication authority is not providing sufficient grounds to argue before them, and the cross objection is available at the time of adjudication. But that is not being given to the agreed adjudicated person. So that cross objection and other things may be sought for in this tribunal.
So anything additional evidence or a fair opportunity should be given to the other party.
That is what.
Otherwise, it can be challenged.
It should be challenged. You mean to say that while filing the appeal itself, it should be challenged, you mean?
Sir, wait a minute, sir. I am the appellant. You are the department. Okay,
yeah.
So I filed appeal, you filed cross objections. So during the course of the hearing, I feel some document evidence or witness is required.
Yeah.
So I filed an application to the tribunal. So the application is considered. So while considering the application is given to the department also. So the department is having every right to restrict the additional document evidence and so after hearing the application as well as the objection from the department, then only the tribunal will decide. So as to whether the additional document evidence is allowable or a witness is allowable. If it is not done so, the said order can be challenged.
Again, this adjournment is only for 3 times, even in tribunal also.
It is this three type is common to all. See,
Yeah.
even NCLT, National Criminal Tribunal, so the same thing is there. In income tax tribunal, the same it is there. So
Yeah.
all cases is the same, but so many adjournments are given.
Thank you. Thank you. Thanks for the presentation.
So I'm
Thank you, sir.
insolvency proposal. The cases to be decided within 180 days. So, but the cases are not closed even after the lapse of 5 years. So, because
Even in appellate authorities also, they are keeping the cases pending for about 4 to 5 years, 6 years also. Even the hearing itself is not coming now.
you know,
There are
what
about
will say
10,000
finally
cases.
what will say, sir, finally,
Yeah, about 10,000 cases per appellate DC. I don't know how they are going to complete the appeals.
it is on their own personal interest and the cooperation extended by the parties to the case. So, for example, 3 adjournments are given. So, after the 3 adjournments, no adjournment will be given. So, what will say, according to the convenience, it is not mandatory, it is directory. So, it is
And
directory.
one more thing, this delay condonation. You told that 3 months the usual period, another 3 months. Beyond that, it won't be given in a tribunal also. So the General Classes Act will not be applicable for tribunal also.
Yes.
Yes,
Beyond
sir.
3 months, delay cannot be controlled.
Beyond 3 months, they cannot be condoned.
Tribunal is not having power to control
Empowered.
delay beyond 3 years. Sorry, 3 months.
Well,
So if you want, you have to go to High Court.
yeah, tribunal is the highest authority. Can it not be given if the General Classes Act being implemented over there? It's not possible.
So for whatever general counsel, we have to give
It's only in High Court.
before the tribunal. Without saying they will not on their own mouse, they will not apply the General Classes Act.
Nice. So in so many cases, the appeals not be filed within the time in the appellate authority, and they are referring it to High Court. Somebody is going to High Court and getting it done, reinstating that appeal, etc., etc. Okay. Those cases which have been missed now, can they approach that tribunal? That is what people have been waiting for. But now it is said that it is only beyond 3 months, it can't be accepted. You know.
Yes.
So there is no other way than to go to High Court. Yeah.
Even in some cases, in sister matters, I say, so tribunal has not been formed. So here no judgments are made. In the other income tax and the High Court cannot direct the tribunals. So to delay the mandatory period more than 3 months. In some cases, not in all cases. The genuinity of the cases are also there. So the High Court will not straight entertain or reject it. So they will consider the genuinity. So some people may file after 1 year. Okay. The tribunal definitely will not accept the delay continuation. So they straight away reject it. So if we file appeal before the High Court, so the High Court will analyze the reasons. So whether it is genuine, whether it was entirely 100% prevented from filing appeal. So in such cases, we direct entertain appeal despite insisting the limitation period. So I came across so many cases.
Thank you.
Thank you, sir.
Thank you, sir. Thank you, sir. Ramesh.
Okay. So mobile number, email ID will be provided.
Yes. Yes, sir. We will share it through the PPT. Along with the PPT, we'll share it.
PPT, sir. Another one is
compendium on GSTAT, that also will share. It has a detailed sections related to this topic, which will be very helpful to you. So that also will share with you.
Sections, rules relating to the first appeal to the tribunal will be given to you, sir. Thank you for all your cooperation.
Thank you, all the participants. Thank you, Govindarajan sir, for addressing the audience. Very well, you have explained in depth. I think this is one of the best, webinar where in-depth discussion has been taken place, where even dress codes, how to appear, that in which dress code that is, and how many copy of the appeal forms, and what are the spacing for the 1.5 double space should be there in the application. That so minutely you have explained every point. So that is really helpful for the audience. Thank you so much once
Thank you,
again,
sir.
sir. Yeah. So until we come with the next topic, it is thank you from Online Tax Update. Thank you so much.